Thank you for joining this episode of our webinar series on best practices in e-discovery. Today's session is focused on best practices in case timelining. We've got a lot of information to cover today, so I'll quickly move through the introduction. My name is Jeff Fugit. I'm Vice President of Sales and Marketing for Lexby, and I'll be the moderator for today's event. Our webinars take place monthly and cover a variety of relevant e-discovery topics, trends, best practices, and strategies. Space is limited to the capacity of our webinar platform, and with the popularity of these sessions, I recommend registering promptly for those that are of interest to you. If you have technical issues or questions, please email us at webinars@lexby.com and we'll address those right away. Our webinars are available online at lexby.com for viewing via streaming video or downloadable as a PDF presentation or MP3 podcast. You'll find this webinar and a complete listing of other webinars at lexby.com. To be notified of future live and on-demand events, please email us at webinars@lexby.com or follow us on LinkedIn. Based in Austin, Texas, we provide a very affordable, cloud-based e-discovery platform as well as services. We specialize in equipping the boutique firm with an e-discovery solution that gives them full control over the e-discovery process, DIY capabilities, and incredibly fast performance. We're the industry's most affordable and full-featured DIY e-discovery platform. We're the industry's fastest e-discovery processing and document review platform. We deliver the industry's fastest return on investment per a study that was done last year by G2 Crowd. And we have a team of experienced e-discovery specialists and expert consultants who are all ACET certified and standing by to assist on a moment's notice. If you'd like a demonstration of our platform, simply email us at sales@lexby.com and we'll get that scheduled. Joining us today is Angela Cardinale. Angela is a senior e-discovery specialist at Lexby, specializing in working with clients that handle e-discovery and complex litigation and requiring a high level of precision and expertise. She is certified by the Association of Certified E-Discovery Specialists. Angela is also a litigation paralegal with 15 years experience with both plaintiff and defense law firms in a variety of practice areas. Before I turn it over to Angela, I'm going to ask a couple of polling questions to set the stage for today's presentation. Our first polling question is, do you currently utilize case timelines for your matters? Yes, no, or what is a case timeline? And while you're answering that question, I'll thank you for participating in today's polling questions. And the next polling question is, what percentage of your matters do you consider document intensive? All right, we've got a few more answers coming in. And I'll go ahead and close that poll. And without further ado, I'll turn it over to Angela Cardinale. Angela?
Thank you, Jeff. And welcome everyone to today's webinar. Today, I want to discuss with you the importance and benefits of timelining in e-discovery. I think it's a really important topic because I think that it's being overlooked a lot in the industry, that e-discovery software should not only be a tool for reviewing and producing your ESI, but it should also be a tool for efficient organization of your data. This is really important because that ESI is ultimately the supporting evidence for your arguments and your case analysis. So I want to cover why I think timelining is so important now and the reason that has become more crucial. I also want to discuss how timelining can assist in that early case analysis, or ECA, kind of the way that we used to do it and the way that we can do it now with e-discovery software that has timelining features available. I will also discuss how timelining can sometimes be disjointed or disorganized, and the pitfalls of ineffective or inefficient timelining, and then what you need it to do, what you want good timelining software to do for you, and a couple examples of how to use timelining in your workflow and case management. And then I'll show you an example in the Lexby platform. Our timelining feature is called Facts and Issues, And it is more than just a linear timeline. It gives you the ability to craft a case theme linking to documents that will ultimately translate into witness examinations and trial prep. Moving on to my next slide, I want to talk about first why it's more important than ever before to use some type of timelining software in these large ESI-heavy document reviews. The simple fact is there's just so much more data than there has been before. The amount of data continues to grow in our cases, and the sources of our ESI is continuing to increase as well. We're looking at today various types of ESI that we never considered discoverable but previously. We're now dealing with integrated messaging and group chat applications, as well as text messages. So much more than just the emails and other electronically stored or created ESI that we have been dealing with previously. And the more there is, the more ESI there is, the more we have to review. And during our review, we're trying to determine how much is discoverable. Once we identify what is, we're trying to find those key documents. And once we find them, how do we organize them in a way that we can access them again later, still with the understanding of what role they play in our case, which can sometimes be months after we have started that initial review. I remember as a former paralegal, getting banker's boxes in from clients and opening the boxes and trying to identify the key documents, being able to say this box is going to go to the front of the stack because I'm looking over here and this looks like this is not going to contain anything that is incredibly discoverable. So, we tried to parse and identify which ones we needed to look at first and which ones we had to focus on for our first round of productions. Well, how do you do that when you're dealing with electronic data? You do that with the creation of a timeline. You start to build this timeline based on the data that you begin reviewing in that initial review. You start linking them to acts and facts in the story. And that electronic data is now giving us access to a recording of contemporary thoughts that we didn't have access to before. We had the hard copy, but we may not have had all of that, all of the impressions given in all of those kinds of ESI that I was discussing, all of that messaging and communication that we take for granted right now is giving us an idea more about what people were doing at the time and why. Another reason that I think it's really important is that with these large document reviews, cost considerations are part of the management plan. When we sit down and start creating those review and management plans of these ESI cases and creating the budget, we have to pass off some of those more costly stages to associates and contract reviewers and even technology assisted review that we're using more frequently to do that initial review just because there are so many documents and not a lot of time. Because of that, those senior attorneys aren't doing as much of a detailed review of the key documents as they have in the past. This gives them a diminished appreciation of the documents and the data, so they need something else to rely on, and the timeline is really going to tie in the story of facts and the supporting evidence for them. So that's another reason that I think timelining is really critical in e-discovery cases. There is still the challenge of finding the key documents, but now that challenge has exponentially increased for us because even though we're still probably going to come up with the same, handful of really critical documents to support our case, we're looking through exponentially more data than we have been as this, as all of the different types of ESI continue to grow. So timelining helps us track them and it also helps us identify not only important documents in the story, but gaps in our story as well. And another thing that I think is important in at the timelining process is that we're educating ourselves about those key documents and the case facts early on, which helps us make decisions and evaluate our case and identify who the most important key players are, identify what depots we want to take first, find gaps in the data, and that will help direct us in the collection of additional data sources and identification of additional custodians. So let's move on to my next slide, where I'm going to discuss additional benefits about that early fact analysis. Custodians are going to be a critical way to fill in the story. We need to identify additional data sources through those custodians. And custodians can be someone who's in possession of this potentially relevant data. So it could be a litigant. It could be someone who receives a subpoena. It could be the IT person who simply has control over shared drives and will be able to identify additional sources of relevant ESI for us. Coordinating a witness with the evidence is critical. So using the timeline as you review the ESI and mapping data in conjunction with those witnesses and as you interview them will help you prepare them for deposition testimony. So really understanding the facts and the evidence before you put your witness on will ensure a successful depo. It will also prevent your witness hopefully from being discredited. Again, I've been there. I have seen it go down quickly in a deposition when we were not prepared for the submission of a key document that maybe we had received, but just no one had seen it or reviewed it or didn't think to prep our witness with it. So using an efficient timelining feature will help you not only understand what data you have, what you're missing, what you're going to need, but it's going to help you in preparing your witnesses. Another benefit that I don't think many of us consider to early timelining is helping you determine early on if facts and documentary evidence will support the legal elements of your actions such that you can develop it from the outset of discovery and depositions and then relate those facts to a jury instruction that you want to use at trial. And lastly, I think that an advantage that is probably a little bit more obvious than the jury instruction advantage is building your coordinated case story. I mean, that's kind of the overall reason that you would create a timeline is to understand the story. So you want to figure out where you're trying to go with your case and tell it in a coordinated way to the triers of fact. So, you're including, again, those legal elements of your case, but also really building a succinct story of the facts that are consistent with the documentary evidence. So that's when the timeline becomes an outline of the story and really translates into a trial theme or a trial outline. All right, let's move on to my next slide. I want to get into the relationship and the differences between timelining and early case analysis, or I should say the difference between how we used to do early case analysis and how we can make it more robust now with timelining features in e-discovery programs like Lexby. I think that the original use of ECA was to assess our case facts, obviously, and the witnesses that we needed to identify, those key players and the key document identification. And of course, we're navigating through the banker's boxes back in the good old days, trying to do that case assessment and witness and key doc identification. Fast forward to how we approach review today, dealing with ESI, and we can use tools like timelining and analytics in that early case assessment. And what I mean when I say analytics is that we can now do a quantitative analysis of our ESI. We can use date visualizations quickly to show trends in the data. So we can pull out gaps in our data, like gaps in emails or the statistical distribution of email and other documents by time and custodian. So that is really providing us more insight into what data we have and what we might be missing, which might be the more crucial benefit here to using timelining and quantitative analysis. Both are valuable and necessary to do in your case assessment, and Lexi's eDiscovery platform gives you the tools to do both. Okay, let's move on to my next slide, talking about what are the pitfalls of poorly executed timelining, or just not doing it or doing it too late. Obvious answer to not doing it at all is not knowing if your witness could potentially be testifying inconsistently with evidence. Why would a witness do that? Some witnesses may not remember all of the digital evidence that's out there, and as we've already discussed, that digital evidence has grown. So they may not be thinking of all of the different types, not just email correspondence now, but text messages and social media messaging. They may have selective memory of the past actions that could easily be contradicted by documentary evidence at a deposition because they are remembering something in a more positive light, potentially. And this is why the digital evidence needs to be examined. We have to organize it better so that we can help the witness better remember and integrate the digital evidence with their testimony to keep it all consistent. And, failing to keep witness testimony consistent with evidence really puts them at risk for being compromised, when they're sitting there in the depot on cross and then being discredited. I personally have had two experiences working as a litigation paralegal in the past that could have been prevented with a good timeline in any kind of program. The first instance, I think, is more common and more obvious. We had a witness whose testimony was discredited with a piece of evidence. So an answer was given and an exhibit was submitted that directly discredited that witness's answer. It wasn't that we didn't necessarily know about that document being produced, but it had unfortunately not been linked to that particular witness. And that is because that witness appeared in the case or in the story of the facts later on. And it just wasn't linked back to that particular witness. A timeline would have made that visually more obvious to us. So it wasn't that the witness wasn't prepared well. It wasn't that we didn't necessarily know about it. It just wasn't on our radar because timing showed that this witness became critical or involved later after this particular piece of data was created. Another less obvious example, and one that really left me with more of an idea that timelining was critical, and I really started implementing that in all of the cases that I was involved in from that point on, happened when a witness that had been prepared on multiple occasions and had very clearly articulated that they had communicated and or provided notice to another party in the case on multiple occasions and had followed up, etc. we had a few examples in our evidence of, that reinforcing that statement that communications had been made. And obviously, we did not take it upon ourselves to chart everything out or to plot it out in a timeline or any kind of linear view. Apparently, we also had not even really listed the dates, so that someone said, hey, that's weird. There's like this huge chunk of time where there is no evidence documenting communication from witness A to witness B. However, the opposing counsel's attorney had done so, had prepared in such a way, and they laid it right out there. Are you sure that you communicated with them, in this frequency that you have stated? Because here is a timeline and shows the last communication on this date to the next communication on X date, and it became very clear that we dropped the ball. It wasn't that the witness themselves didn't recollect or was being selective. They really thought that they had made all those efforts, but when you laid it out, it shows that there was a lack of communication and notice given. Another danger that is not as obvious as the two examples I just gave you is you're failing to take that advantage over opposing counsel's witness. So if you are aware and you have a good idea of where, for example, those gaps lie in the data or the evidence, or you have some that support a particular fact that you want to drive home because it helps your argument, you can tie the witnesses down to that evidence or commit their testimony to whatever it is that you're trying to prove, as well as tying the witness to their testimony and possibly avoiding a later retelling of that if they are deposed again or put on the stand at trial. And the last example, which is probably the worst, I would think, although, it is not great to have your witness be discredited. However, thinking that you have an okay case or thinking that you have a defensible case from the beginning because you may not have fully organized all the data that has come in, and then realizing that there is something or multiple things out there in the data that are truly bad facts, that you now have a completely different case than you thought you did, and that you represented to your client after, early case assessment time rolls around, that this was going to be a defensible case. And now you realize it is going to require the retainment of multiple experts that are probably going to give you negative reviews, and you're going to have to keep going and keep spending money on the defense when, if you've known 6 months prior that these bad facts existed, it may have never gone past discovery and would have gone straight into settlement negotiations. So those are all examples of what the dangers are, what the pitfalls are of not having a timeline. Let's move on and talk about why sometimes, even if you make the efforts to timeline the data in your case, it may fall a little short. A few reasons why timelining can be ineffectively done, if done at all, still ineffective, are that we've already discussed a lot of the senior attorneys are just not as involved in the early document review stage when we are dealing with these very large data sets in these e-discovery cases. So they're not involved in the early collection and review. That means that it gets delegated to associates or paralegals, and that even though that delegation is important because, again, back to the budget and being cost conscious, that leads again to the senior attorneys not being aware or having a really strong grasp of all of the key facts and documents in the case. Again, the timeline would remedy all of that. And then lastly, inadequate tools being used, like trying to use WordPerfect or some other Microsoft product, is basically limiting you to a static, not dynamic timeline. It doesn't link to anything. It seems to always be out of date because every time something new comes in, that one person who drafted that timeline on their desktop has to go back and update it and then distribute it. And then again, by the time it like hits the attorney's desk and they're getting ready to go to depots, it could be again out of date. So what do we want? Let's move on to what good timelining software should be for us, what we want it to do, and what it's potentially not doing when you're not using a product like Lexby. It should be intuitive and easy to use. Intuitive to the user such that it can be easily accessed and shared to the entire litigation team. Obviously, it has to be secure. You want it to be accessible at any time so that at any point, any of the members of the review team can log in, log on, and make additions to the timeline. It also has to be linked to the documents and any of the attorney's notes, internal notes and coding, internal annotations that can be done as well. And it has to allow the user to filter and sort on key documents like the key players, the participants, issues, definitely date ranges, and other internal coding that may be used. You have to be able to link the documents to the timeline as well as filter on metadata, because you need to be able to isolate that bigger, broader, entire case timeline down to whatever it is that your immediate need is. Is it for an evidentiary hearing? Is it for a witness deposition that's coming up? It may even be for specific issue analysis. So once you have built out the timeline across all of the data that has been reviewed, and remember, we want our e-discovery software to give us both features so that when we're doing the initial pre-production review, post-processing pre-production, that's when we gather all the reviewers together, or even if it's just one or two on the team, and start reviewing for all of those issues as well as relevance and privilege. And if that's done from the beginning, then it's done across the life of the case. You need to be able to quickly access documents that get linked to pull them out for exhibits. And like I said, filter on certain types of metadata, because you will need that timeline for various steps throughout the phase of the case. Okay, now we have good timelining software. We're using it in such that we're creating it in a Lexby platform. And what are we going to do with it now? How will it help you once you've put all of that time and effort into creating a good timeline? The witness prep and cross. The two stories I gave you would have been avoidable had we done a timeline like the ones that I've been discussing. Transcript analysis is something that I haven't mentioned yet, but I'll show you an example in a few minutes of how you can do that. And it's something that I think is not commonly thought of when timelining an e-discovery. Timelines can be used as a more structured fact extraction. I think more functional really than the old-fashioned depot summary. Even if you're working in an e-tran where you can click and hop around to different pages, you're not getting the same benefit by using it in a timelining feature in an e-discovery software program, because by structuring the facts out of said deposition, you can then filter or even group together to view issues that could be addressed in different parts of a deposition and even in more than one deposition. So you can even compare and contrast multiple depot transcripts in a timeline. You can also relate key facts to supporting exhibits and other evidence, which you can imagine are going to help you if we're going to go back to that discrediting a witness later on down the road scenario. So, transcript analysis, like I said, I think is something that is not often thought of or utilized as much as it should be in a timelining software. It's obviously helpful in the case evaluation and settlement negotiations. You're protecting yourself against the leaking of those bad facts. You are able to tie in facts with the original documents and notes, and potentially counter what's being brought up by opposition, because if you have that timeline with you or in front of you, or you just know that you have a strong understanding of everything, again, you can counter kind of, on the fly when things are brought up in settlement negotiations. Client meetings. Moving on to my next slide, I'll continue a couple more good uses of timelines. So client meetings, obviously you want to be as well educated as possible when you're talking to a client about the case, where it's progressing, if it's strong, assisting them with maintaining a more accurate case valuation. And, seeing the timeline will also help them or the parties or other witnesses kind of see how their testimony is fitting into the bigger story that you're telling. Obviously, motion practice, knowing the timeline, being able to quickly filter down to those documents that you have already linked to these various issues, gives you the ability to export those documents that you have filtered to, meaning get them out of your e-discovery platform and print to add to a hearing notebook, and you are ready to go. Having your key evidence previously identified, organized, timelined and mapped out, and then linked to the facts and issues in your case allows for a really quick and effective response. So this also translates into trial prep, keeping your timeline up to date all the way during just like all the discovery testimony phases will allow, and trial, even think about that. If that was updated to include each day's trial testimony even more, does it allow you to quickly and effectively cross and support your argument. And lastly, it will also be the basis for any demonstratives that the jury or judge may review. Now I'm going to give you some examples of how you apply these best practices I've been discussing in Lexby's e-discovery platform. So in my next slide, you will see what is actually a step that kind of precedes the timelining feature that we offer, or any timelining feature really. You first want to identify and set up your key players. In one of my earlier slides, I referenced ESI data mapping and witness interviews. And this is what I meant. You will first want to identify and set up your key players, the companies, organizations, parties, deponents. You want to identify all of the case participants that could be sources of ESI, meaning they may be factually related to the case in some way. You want to identify or map how they're related to each other and where their ESI lives. So you can use this example or any version of it as the basis of your list of witness interviews, and then you're going to integrate the ESI data mapping again. What data do they have access to? Is it a share file? Is it an email account? Is it a Slack hangout that they use to communicate with their other coworkers? So this is just an example of how you would begin. Identifying where the data lives, who it's coming from, and the participants that you will have on your radar. Lexby offers a feature called Facts and Issues, which is designed to help our clients organize their documents and construct timelines of their cases, even at the very early stage of the case. So case timelines can include facts that support claims or your theories of your case. And then the facts and issues function, which is our timelining feature, is so useful when prepping for depositions, evidentiary support for motions, and preparing for trial. So it's giving you all of that good stuff that I said good timelining software should provide. So my next slide is an example of where you begin. Issues are created based on causes of action or those anticipated jury instructions, those story facts that I talked about, and then the issues can also be related to claims or defenses. So it can be styled in a few different ways. On my next slide is an example of creating a fact. So once the issues have been set up and structured, you can create facts as subparts of those issues. So those facts are what is associated with your document. So that is where you find the documents that will be your supporting evidence and link it to the fact you've created. So we're looking at, on the left side, you'll see under the facts and issues demo, the tree of broader issues that have been created: bankruptcy, financial matters, fraud, etc. And then in the center, you see how you can populate different fields when you set those facts up. There's a title, there's a start and end date, if it's contested, if it's a material fact. And then on the right side, you'll see how you can even assign custodians to that. And on the bottom of that screen on the right side, you'll see you can assign a fact to multiple issues. The fact funds being misused may apply to not only the financial matters issue, but negligence and liability. And then on the next slide, here is what it looks like from a couple different views. So that top window showing 4 facts is what it looks like when you're on the facts and issues page in Lexby. So that feature page will give you the ability to see all of the facts that you have created in your case, or filter to only a specific set of facts based on different filtering logic, date ranges, custodians, keywords, or specific issues as well. And then at the bottom, we're looking at the actual document. So under that full document view, there's the document itself. So the fact that we're looking at and the document that's circled in red is the Enron.203. The fact is, the magical word of the day is burn, baby, burn. So then look down below and you'll see where that phrase, burn, baby, burn, is set out in the document. And then on the right side of that document is another view of the facts that have been associated with that document. So not only can you see all of the facts listed in the case, the timeline to the right, all the documents that have been associated with each of those respective facts, but you can also access this in an individual document view. In the following slide is just an example of how you can filter on the different facts and issues you've set up. So if you look at the different filter options, you can filter on the fact title, whether or not it's contested, if it's a material fact, the document name, the custodian. I mean, you just have a lot of options and flexibility in this feature. And on the following slide, again, an example of a different view and a different purpose. So here is a use of facts and issues in Lexby for prepping for a witness testimony. You'll see in the top window, there are the facts that have been filtered out by custodians. So if you were reviewing based on specific custodian testimony, because you are maybe preparing to cross-examine at trial, and you want to find inconsistency in testimony or tie them to previous testimony given. So you can do that with the annotation editor, which you'll see at the bottom of the slide. You'll see where the highlight is on the testimony. Okay, and you recall when Mr. Lay became a client of Nations Bank. So we're tying that to the fact Mr. Lay becomes a client of Nations Bank. So this is one of many documents you'll see on the right side of my slide that has been linked to that particular fact. And just by clicking on that blue hyperlink title, this document pulls up, and here's the page that has been linked to that particular fact. And then again, you'll see on the right pane of that transcript view that the facts tab is exposed, and you can see that this particular document has actually been associated with multiple facts. So you can delete or edit them from the singular doc view, or again, from the main facts and issues page. And on my next slide, I just quickly wanted to show yet another example of how you can tie documents into witnesses. So as you're doing that initial or even second pass review, you need to start not just identifying documents for relevance and responsiveness, but you need to start coding them for additional issues and upcoming depositions. So you can see where this particular document has been tagged to Mr. Lay and Mr. Skilling. And the bottom of my slide is just an example of a document title. So there's the Supreme Court of the United States is the title. You could click on it and open it up in this document view, but then look at these other metadata fields that have been populated where you see it's been checked for witnesses Lay and Skilling. And my last example is how you can use the facts and issues timelining feature to help you in your motion practice. When you set up facts, you can designate whether or not they've been contested and whether or not it's a material fact, which are those most important in a case because they relate directly to the issues of the action. This assists you in your motion practice because you can quickly identify what documents you will then want to export from the facts and issues feature in Lexbe, giving you PDF versions of all of those documents that you see linked in the docs column, and they will then become be the exhibits you attach to that motion and take with you to argue your motion. And we're now at my last slide. So in a brief summary, timelining is critical now more than ever. The exponential growth of ESI and cost considerations are dictating that associates, paralegals, and even technology are the early reviewers, and the senior attorneys are less involved in that process. Because of that, those senior attorneys have a lesser appreciation for the documents and need to rely on a timeline, as I earlier stated, to tie in the story and the supporting evidence. And how do we do that? We use good timelining software like Lexbe. It must be accessible to the entire team. It must be secure, and online is preferable so that it is accessible to everyone at any time. You must be able to structure it by issue, key players, and materiality of the facts. You must also then be able to link all of those facts and issues you've created to actual documents so that once you have completed that timelining process, you can access those documents and use them in all of the examples that I've provided. All of the challenges that we're facing with these ESI document-intensive cases make timelining a critical part of the case management and workflow. Timelines will assist you prepare your witnesses, prepare yourself to cross opposing counsel witnesses. Timelining will give you a good case valuation and clear understanding of the strength of the case that you are handling, give you the ability to clearly communicate with your clients and keep their expectations in perspective. Timelines will assist when preparing for dispositive motions and trial. And thank you all for joining me today as I discussed what I see as best practice in litigation timelining today. And now I'll hand this back off to our moderator.
Thanks, Angela. That was a fascinating presentation on the development and use of case timelines. Lexbe is purpose-built for the boutique firm with advanced capabilities that surpass those of Big Law, but for a fraction of the price. We're an Amazon Web Services partner, which means with Lexbe, you'll have the industry's best cloud infrastructure and security. Not only do we auto-scale based on the size of the incoming document set or ESI, so we get you from document ingestion to review faster and handle huge productions, but we also equip you with the ability to automatically build a case timeline with responsive documents. Therefore, we make it easy for you to handle those document-intensive cases in-house. Unique to LexB is the Uber index. It gives you the largest searchable data set because we capture native characters, OCR characters, we OCR the images and capture those characters as well, in addition to translated characters, and all of those are concatenated into a single index. The reason this is important is because there are several use cases where you'll miss evidence if you don't capture the native characters and OCR characters and have all of that in your index. An example is if there are hidden fields in an Excel spreadsheet, then you have to have native character extraction to make that data searchable and to capture that. We also equip you with advanced capabilities that are very simple to use. Near-dupe groupings is one of my favorites because it helps you find similar contextual documents, which speeds the review process and is very helpful in preventing privileged docs from slipping through the cracks. Email threading and analysis gives you the ability to quickly identify relevant emails. Technology-assisted review helps speed the review of very large document sets by using an artificial intelligence predictive coding algorithm that quickly identifies responsive and non-responsive docs. And then neural machine translation, something that was born out of our technology partnership with Amazon Web Services. We give you the ability to quickly and efficiently identify and translate foreign language documents by utilizing an advanced artificial intelligence algorithm. Last but not least, you don't need to have big law IT or lit support teams to compete. LexB gives you the capability at your fingertips. And we also have a team of BASED certified e-discovery professionals that are standing by to assist clients on a moment's notice should they need help or staff augmentation. And we have a 24/7 IT support system. And with that, I'll ask our last polling question, and that is, would you like a demonstration of the LexB Discovery platform? And while you're answering that, I'll thank you for attending today's session. We'll be making the following available to webinar attendees: a recorded streaming version, an MP3 podcast, as well as a PDF. Please let us know if you have any questions or comments about this webinar or suggestions for future topics. This webinar is part of the LexB eDiscovery webinar series. And for notices of future live and on-demand webinars as part of this series, please email us at webinars@lexb.com or follow us on LinkedIn. And watch your inbox for an invite to our next webinar on best practices in eDiscovery. Thank you for joining this episode of our webinar series on best practices in eDiscovery.